Hi, this is Harry Margolis. In today's lesson from Estate Planning 101, we're going to talk about the durable power of attorney. And before we launch into what it is, I'm going to say that I think it is the most important estate planning instrument for most people. And it's interesting because when most people think about estate planning, they're thinking about what happens after they die, what happens to their stuff, basically. But a lot of estate planning has to do with what happens while you're alive. And the prime example of this is the durable power of attorney. The purpose of the durable power of attorney is to appoint an agent, or can be more than one agent, to represent you and really stand in your shoes to make legal and financial decisions when and if you're unable to do so. As the slide says, the agent is often called a, quote, attorney in fact, which can be a little confusing because in most cases the agent is not an attorney, meaning not a lawyer, but anyone, but they get that title. But I think for most people, the term agent, someone who acts for you, is probably an easier term to understand. Now, you can appoint one person as an agent. You can appoint two people as agents. You can actually appoint any number of people, but I think that gets confusing. So we recommend no more than two at a time, but you can also appoint successor agents. So if the first person can't serve, then the other person can step in as the first person's successor. Now, most powers of attorney that we do for our clients are effective immediately as soon as they're signed, even though their purpose is not to be used until the individual becomes incapacitated. But the reason we do that, as opposed to what's called springing powers of attorney, and a springing power of attorney is one that only takes effect upon incapacity. The reason that we prefer immediate powers of attorney is because it can be hard to prove incapacity. So you have this power of attorney that says, I appoint John to stand in for me and handle my finances if I ever become incapacitated. And John then takes the power of attorney to the bank, and the bank says, well, how do we know that you're incapacitated? So that creates a problem, and so we prefer to avoid that if possible. Hopefully, if you trust the person to handle your financial and legal matters, you also trust them not to step in when they shouldn't. And in addition, if they do, you can always revoke it. So you might want to know that ahead of time in any case. So there is, even without springing powers of attorney, sometimes difficulties with banks and other financial institutions in terms of accepting the documents. They should accept them. The law says they should, but it's hard to fight them if they put up some resistance. So there's two things you can do to really prepare for such a challenge. The first is update your power of attorney every 5 or so years. I just executed a new one. For some reason, these financial institutions have what I term the Staleness Doctrine, that if the power of attorney is too old, they're going to give you trouble, even though it's pretty perverse, since presumably if you're incapacitated today, you are more likely to have been totally cognitively intact 10 years ago than you were 10 months ago. But anyways, the 10-month-old power of attorney is going to work better than the 10-year-old one. And the other thing is that many banks and financial institutions have their own power of attorney forms. So if you do banking at a particular bank, or your investments are at Fidelity or Vanguard or Charles Schwab or any place like that, ask the people you deal with there if the institution has its own forms that you can sign in addition to a general durable power of attorney, and that can help a lot. And you probably won't find these forms on their website. You have to ask for them. They're a little, they seem reluctant to hand them out. But if you put a power of attorney in place, naming someone you trust to step in for you, you're going to save a lot of trouble for your family members when and if you become incapacitated. Without that, they often cannot act if necessary, whether it's to sign admission papers to an assisted living facility, to get out of an apartment rental, to convey real estate, or simply to pay your bills. So the best thing you can do in terms of estate planning for your family is to execute a durable power of attorney.